everybody. I just wanted to give you a little background on some of the terms you're going to see this semester so you're familiar with things as you're reading and watching the videos. So in the United States, when someone is charged of a crime, the people or the state is in charge of prosecuting that case. And they use the term hand in hand. It could either be the people of California or the state of California. It just kind of depends on what the district attorney in that area wants to call it. So if you see either of those terms, it tells you it's a criminal case, and it tells you that that's who's going after the defendant. And the defendant is the person who's charged with the crime. So if we have someone named Johnny, and he goes to Bruno's and he steals from Bruno's, shoplifting, the people would be the one prosecuting Johnny for the crime. So you'll see the title of the case be the people versus Johnny, or the state of California versus Johnny. It could be either way, and it means the same thing. When there's a criminal trial, the prosecution, the people, have the burden to prove that Johnny did the crime. Johnny has a presumption of innocence, so he is believed to have not done the crime, and then the people have the burden to show enough evidence that Johnny actually did it. And the amount of evidence they need is beyond a reasonable doubt. And what that means is it's everybody on the jury, the 12 people that are sitting there, believe, no matter what, that Johnny did shoplift from Bruno's. So that evidence happens at a trial. And at the trial, the people or the prosecution have to show different pieces of evidence to show Johnny actually did it. So in the case of Johnny, they may show a video of Johnny walking into Bruno's. And then they may show a video of Johnny walking out. And as he's walking out, he has the item they say he stole in his hand. That would be two pieces of evidence towards proving that Johnny committed the crime beyond a reasonable doubt. So when the people believe someone has committed a crime, they file a document with the court called a complaint. And it says the people versus Johnny and complaint on the top, and then it lists out every crime they think Johnny did and when he did it and where he did it and who the victim was, what he took. So that Johnny is then given that complaint at his first hearing, which is called an arraignment. And at the arraignment, Johnny can say he did it or he did not do the crime, and that's called a plea. He can plead guilty or he can plead not guilty. The third way he could plead is guilty, no contest, because he believes he has no chance of winning for whatever reason. So he can plead that he did it, but he's not going to say he actually did it. He just doesn't feel he has a chance to win. So after the arraignment, there's a hearing called a preliminary hearing. And at that preliminary hearing, the people are going to show they have enough evidence to go to trial. And if the judge finds that there's enough evidence, then the trial will go forward. At the trial, the first day of trial, Johnny can then plea again. He can say, forget it, I don't want to go to trial, and plead guilty. And if he does, he is then sentenced. Now, if he doesn't plead guilty, then a jury comes in. There's 12 people on a jury, and they decide whether or not the people have shown enough evidence to get beyond a reasonable doubt, and if so, then Johnny is sentenced. Now, if Johnny is sentenced and he believes he did not do the crime, he can then appeal the verdict to the Court of Appeal. And in California and Lake County, our Court of Appeal is in San Francisco. So he has to file papers with the court in San Francisco, and then in a few months, he would go to there and argue that he didn't do it, or his attorneys would. Then if he didn't like what the Court of Appeal said, he could go to the California Supreme Court and argue that he didn't do it for a variety of reasons that happened at the trial court. So If he is found to still have done it at the Supreme Court, if he appealed all the way and the Supreme Court said, no, you did it and everything was done right at the court, then he'd still have to serve whatever sentence was imposed. Now, the federal courts have the same exact system. So if you commit a crime or you're accused of committing a crime in federal court, you go to a federal trial court. They have a federal court of appeals, and in California, we are part of the Ninth Circuit. And then the Supreme Court for the federal courts is in Washington, D.C. Now, other terms you're going to see this semester include search, and that could be searching someone's person, like in their clothes, along their body for things, or it could be searching their house, their car. And a search doesn't have to be just looking for something specific, because sometimes officers happen upon something and it's still considered a search. And there are times when those items aren't allowed, and there are times when those items are allowed. So we'll talk about that in a couple weeks, about when searches are okay for law enforcement to use and when they're not. And when people say something, that's a statement. And statements are another form of evidence, and they can be used just like fingerprints, just like a weapon, as evidence in a trial. So if Jane works at Bruno's and she saw Johnny walk out the store with the items that he stole, she can make a statement that says, yes, I saw Johnny do it, and that statement is evidence. Okay, so those are just a few of the terms I wanted you to be aware of. I look forward to this semester, and good luck.